We have reached the point in the trial of the case when it becomes the duty of the court to charge the jury as to the law. During your deliberations, you will determine what are the facts. Determine those facts from the evidence which has been presented from the witness stand and through the exhibits. To those facts you will apply the law which the court gives you in the charge, and then arrive at a fair and just verdict according to the law and the evidence. The plaintiff here seeks to recover damages for injuries alleged to have been sustained in an accident which occurred on October the 2nd, 1968, and a second accident which occurred on February the 20th, 1969. As to the accident which occurred on October the 2nd, 1968, plaintiff grounds his right to recover upon his contention that the defendant failed to comply with the provisions of the Safety Appliance Act in that the handbrake on the car in question would not operate efficiently when manipulated in the customary manner. As to the accident which occurred on February 20th, 1969, plaintiff grounds his right to recover upon his contention that the railway company was guilty of negligence which contributed to cause the accident of February 20th, 1969. You will have to recall the evidence as it relates to each of these accidents. You will also have to recall this charge as it relates to each of these specific accidents, for some of the provisions of the charge relate to the accident of October the 2nd, 1968, and some of the provisions of the charge relate to the accident which occurred on February 20th, 1979. In arriving at a fair and just verdict in this case, or in any case tried before a court jury, a verdict must not be based upon surmise, conjecture, or sympathy for either of the parties, but it must be based solely upon the evidence and the law as given you in the charge by the court. During the charge, the court will refer to the term preponderance of the evidence. Preponderance of the evidence does not necessarily mean the greater number of witnesses, but it means the greater weight of the testimony, or that degree of proof which you find more convincing and worthy of belief. The testimony of one witness in whom the jury has confidence may constitute a preponderance of the evidence. In ascertaining the preponderance of the evidence and the credibility of the witnesses who have testified before you, you may take into consideration the demeanor of the witness on the witness stand, his apparent candor or frankness, his bias, if any, is shown, his interest or lack of it in the outcome of the proceedings, his opportunity for having observed the facts to which he has testified, any prior inconsistent statements, if established by the evidence, and from these and all of the facts and circumstances in evidence, you are to determine the credibility of the witnesses and the weight which you see fit to give to their testimony. Relating more specifically to the accident on February the 20th, 1969, the basis of that, as I have previously advised you, is negligence. You will keep in mind the provisions of the charge relating to negligence. Keep in mind that the accident of October the 2nd, 1968 relates more to what is alleged to be a violation of the Safety Appliance Act. Now, you need not concern yourself with what are the particular details of what is referred to as the Safety Appliance Act or the Federal Employers' Liability Act. While the provisions of these acts are applicable to certain phases of this case as acts within themselves, they will be covered in general by the charge of the court. So a reference to the Safety Appliance Act or the Federal Employers' Liability Act will only be as to the particular law from that particular act which is applicable to this case. Negligence is the doing of some act which a reasonably prudent person would not do, or the failure to do something which a reasonably prudent person would do when prompted by considerations which ordinarily regulate the conduct of human affairs. It is, in other words, the failure to use ordinary care under the circumstances in the management of one's own person or property. Ordinary care is that care which reasonably prudent persons exercise in the management of their own affairs in order to avoid injury to themselves or to their property, or to other persons, or to the property of others. Ordinary care is not an absolute term, but is a relative one. That is to say, in deciding whether ordinary care was exercised in a given case, the conduct in question must be viewed in the light of all of the circumstances as shown by the evidence in the case. It was the continuing duty of the defendant as an employer at the time and place in question to use ordinary care under the circumstances, to use reasonable care for the safety of the plaintiff, and to maintain its equipment in a reasonably safe condition. This does not mean, of course, that the employer is a guarantor or insurer of the safety of the person.
Not too slow?
180.
That's how fast it's going.
I don't know how fast they're going to give it. I don't even know if they're going to give a charge because they haven't gotten to that point. See, this thing I just got, did I give it to you?
Yeah.
What did I do with it? Anyway, that only has the date, and it says that the applications will be received about a month or two from now. So I don't know whether they've arrived at what sort of exam they're going to give. But there's